Good afternoon and welcome to Infopointe, Alphapointe's online learning platform. For over 100 years, Alphapointe has been a leader in the education and employment of those with vision loss. Today's webinar is Your Rights Under the Americans with Disabilities Act, and joining us today, we have Scott Thornhill, our Senior Manager of Public Policy. So as we get started, we do have a little bit of housekeeping. This webinar is designed with accessibility in mind. So that means that for those with total vision loss, we will be describing all of the slides. There is on the top or bottom of your screen, kind of depending on your layout, a control ribbon. You may have to touch your touch screen or wiggle your mouse to get that to show up. It does hide itself automatically. And on that control ribbon, one of the things you can do is go into the chat box if you want to share information with the other attendees. There's also a Q&A box that looks like speech bubbles, and it allows you to ask questions, and we will have a question and answer portion at the end of this presentation. So clicked too many times. Our objectives today, we want to define the Americans with Disabilities Act, identify what your rights are underneath the ADA, and then describe the steps that you would take for resolution if you feel that your rights have been violated. And so first of all, we want to start by saying happy birthday to the ADA. It's hard to believe, but the Americans with Disabilities Act will be turning 30 this Sunday. And so that leads us into our first kind of question is, what exactly is the Americans with Disabilities Act? Well, this was a law that was passed July 26, 1990, and it is a comprehensive piece of civil rights legislation, similar to the Civil Rights Act of the 1960s, which it was labeled, or it was modeled after. And it's considered what we call an equal opportunity law. In other words, those with disabilities have equal opportunities for employment, living, government services as those without disabilities, again, similar to laws granting equal opportunity to those with different gender, skin colors, etc. So who is covered under the Americans with Disabilities Act? Well, first of all, you have to have a physical or a mental impairment, and it has to limit a major life activity, which can include things like seeing, hearing, breathing, learning, walking, that type of thing. So for the purposes of Alphapointe, we work primarily with those with vision loss. All of our clients would be considered under the Americans with Disabilities Act as having a disability. Now, Scott, we have a question for you because the reason we've asked Scott onto this particular webinar is he does a lot with advocacy. At what point is somebody's vision loss considered disabling?
So, Jesse, as you mentioned, so an impairment, the way that, whether it's vision or another impairment, it's something that limits one of those activities like you mentioned. So at the point where your vision limits those particular items and it is not correctable with glasses or contact lenses. The ADA does specify, and just to also clarify one other piece, in 2008, there were some updates to the 1990 ADA that was passed. And so in 2008, some things were clarified because they had really narrowed, the courts had narrowed some of those definitions beyond what Congress had intended. And so in 2008, they clarified some of that. And one of those things got into, partially having to do with visual impairments when it comes to assistive technology and things. But at the point where glasses and contact lenses will not correct the impairment, then that's at the point where vision now becomes a disability that would fall under the provisions of ADA for reasonable accommodations.
And so I think we've all heard kind of the running joke, oh, I'm legally blind without my glasses. And that's kind of a bit of a misnomer because legal blindness, the definition is of visual acuity of 20/200 or worse in the better eye with correction, which would be with glasses. So somebody who wears glasses and is fully correctable with glasses shows up one day and their glasses are broken or they've forgotten them. Under this law, that does not count.
Yeah, and so and also it's the term legal blindness is very interesting because people do use that term a lot, and the reality really is that by definition, you're either blind or you're not. But because it is definable. And so, but yes, so it gets down to glasses and contact lenses not being able to correct it. Although I will say with other outside of vision, you know, other things, the term they use in there, I think is, but basically mitigating factors. So if medication and other things help correct the impairment, you're still considered to have the impairment. Really, glasses and contact lenses. So that's really the only place where it's spelled out very clearly that is correctable at that point. But other things, if you have to take a medication for the impairment, you're still considered to be impaired, even though those other factors may help mitigate the situation.
Thank you for clarifying that. You know, really, we start to get into the weeds very quickly when we're dealing with the Americans with Disabilities
I'll
Act.
be careful. I'll be careful.
No, you're fine. Because there are a lot of nuances to it, and so I think it's great that we can clarify some of that. You know, another way that you qualify is if you have a history of impairment, and so a very common example would be if you have had cancer in the past, that would be considered a disabling condition under the law in most cases, not all cases, but most cases. And so having that history of impairment could potentially qualify you to have protection under the Americans with Disabilities Act. So for example, a place could not refuse to hire you because you have had cancer in the past. And then the other one that I find really interesting is you don't actually have to have a disability if the employer perceives you as having an impairment, even if you don't. So Scott, can you tell us a little bit more about that?
The perception part, or they've actually changed, they changed part of the terminology in that 2008 adjustment to regarding or regarded as having an impairment. So whether it's perceived or regarded, part of that situation is, for example, you know, it could be that someone, you know, is too tall for, you know, for a particular environment, right? It's a place where it's a small space, and the person is you know, like me, a large individual, you know, is a big guy. And so it could be perceived that there's an impairment, even though the individual may not even feel like, you know, they have an impairment. So it can go either way. You know, you can have people who state that they have an impairment that affects one of those major areas of life, but yet the person looking at you may be like, you don't have an impairment. There's nothing, you know, I can't see anything wrong with you, you know, kind of thing. But it can also happen the other way around, where even though it appears as though the individual has an impairment for the job or the situation that's involved, they may very well not consider that themselves, that there's any impairment. But also, Jesse, I think it gets into things along the lines of anxiety, things along those lines where the way that a person reacts in a situation or something may show that they have, it appears that they have an impairment, although that may not have been diagnosed. There may not be any sort of, you know, official statement or history of it having been anything handled by a doctor or anything like that. But it, you know, it certainly could affect the job.
Very, very true. I hadn't thought about that particular example, but you know, anytime that your workplace just assumes that you have an impairment and then makes decisions based on that, then we're starting to get into that territory of whether or not you actually have it. They're acting as though you do, and so now we have triggered the protections under the Americans with Disabilities
Right,
Act.
that's right. And so it's someone having been you know, discriminated against based on the ADA. It almost it becomes a circular kind of a thing. You know, if you have been discriminated against because of this, then you fall under that category as well. And so anyway, so yeah, that one is one that they've had to address multiple times because of some court cases and things that have come along where, you know, the perception piece of it, perception is, you know, as we often say, in the eye of the beholder. And so anyway, so that one's one that if someone has specific questions on, and on all of these, I recommend they reach out. You know, the ada.gov website, there are plenty of resources, phone numbers, all kinds of things. You can get additional information. That's one, if you have a question, I would go to.
So kind of now that we've covered who is covered, you know, there is a lot that goes into the Americans with Disabilities Act that has to do with universal access in design, just to even be able to access a public space. And what we're specifically interested in for this series, this is part of an employment series, is what is covered under the ADA in terms of employment. And so there's Title I of the ADA covers your employment rights, and it specifically applies to private employers with 15 or more employees. It applies to your state and local governments, employment agencies, and labor unions. And then kind of an interesting piece of wording within it is that it covers otherwise qualified individuals. And Scott, what does that mean about an otherwise qualified individual?
So, and this is something important for people in the disability community, or people who have a disability of some sort. So a lot of the fears of employers and people without disabilities is that when you have a law like the ADA, and this was a lot of the criticism that came out when the ADA was being discussed and being passed, and subsequent, amendments and updates to it, some of the fears that come in are, I'm going to have to hire someone that really can't do the job, or I won't be able to fire the person if I hire them and they have a disability. I'm going to get sued. There's a lot of those things. And so otherwise qualified. So you have to be qualified for the job you are applying for. So there is protection for employers at that standpoint. You don't have to hire a person with a disability just because they apply for the job. That wouldn't make any sense. And so the person has to otherwise be qualified. Now, if I have the education, the experience, the work history, and that becomes one of those other tricky areas, Jesse, right? Because we often talk about how do you get experience if no one will give you a job to get experience, right? So if I can't demonstrate that I've done the job that I'm applying for, or that I have the capability to do it through whatever that process looks like, then I don't have to be hired. So you have to otherwise be qualified. On the flip side, if an employer doesn't hire me when I am qualified, and again, it gets into a little gray area because you could, I'm the best candidate, or I'm the most qualified. Well, if there's 3 people and they all have similar education and similar experience, then that becomes an area where the employer has to make a decision. But if I'm otherwise qualified based on experience, education, and history, and they don't hire me, and if it can be shown that they didn't hire me because of my disability, that's when the employer has a problem.
Now, if the employer has reason to believe that that person poses a safety risk to themselves or others,
not
does
required.
The employer?
Sorry.
So to give an example, I used to run roller coasters. I love you to death, Scott, but I don't know that I want you on my roller coaster crew, because we have to be, the essential functions of the job include being able to visually check that the path is clear of obstruction so that we don't hurt anybody.
And you're right on that. So let's say that it's something where you feel like that, that is an important imperative piece of the job, is that you be able to see a particular thing that's happening, a light, or be able to, whatever that might be. It can also, though, Jesse, get into things like, let's say the person has a history of violent behavior, right? Mm-hmm. But now they're on medication. See, this is where it can get murky. But now we're talking specifically with vision, but it covers so many other areas.
Yes.
That direct threat piece. It is an area that employers, just in reading some articles and things, have struggled with, because you're not supposed to consider the mitigating, right? You're still considered to be impaired, but if it's a direct threat, you don't have to hire that individual for that job.
So I think kind of the overarching theme that we're going to come back to in this particular webinar is it's a very individualized law as to how it applies to any specific situation. That there's all kinds of little nuances that you have to navigate, and what looks on paper like 2 similar situations may be vastly different depending on the person and the job and the employer.
Yeah, it is. And so the ADA has terms like substantially limits, the major one or more life activities, substantially limits. Well, there's other terminology. Well, then, the EEOC, which we'll talk about, I know in a little while, the Equal Employment Opportunity Commission started to sort of determine things, in a narrow manner, and that's had to be corrected. So what the ADA, and part of that adjustment in 2008, or the amendment, was saying is that they don't necessarily They want to see that the employer, based on the fact that an individual has stated this disability, they want to see that the employer is taking the steps they're mandated to take by the law, more so than they want to see the analysis of the disability itself.
Mhm.
And so, that's another place where you can run into, to some contentious situations between an employer and an applicant. So just to keep in mind.
Thank you. So kind of continuing your employment rights under Title I. So what I find interesting is that it covers all aspects of the employment process. So kind of thinking back specifically to vision loss, how does this impact a person with vision loss in the job search?
So it does cover the job application process as well. And so most people, especially during this COVID time, but even before this, most jobs today, I use that term most, they are done online. So the applications are online. And so you're also finding now through the application process, you're finding this self-determination. Most people who have applied for a job in the past, I don't know, Jesse, how many years would that be? 5 years or so? Will see that there is a place where you can actually self-determination, self-identify. So you can self-identify that you have a disability. And so that's where now, because if you don't let them know that you've got a disability where this process has been challenging or you're not able to do certain things, then the employer really can't. So it's a catch-22. But starts with the application, goes into any sort of assessments. It does state that that in terms of medical, typically that's after the job offer is made, but before the work starts, they can have medical examinations as long as those examinations are given to everyone. They can't specifically say, well, you told me you have a disability, so I'm going to do a medical exam required for you, but not everybody else. Again, those are areas where I think just keeping the lines of communication open are helpful, people wanting to do the right thing.
I think something that we've seen a lot of our clients run into, or I don't know about a lot, but probably one of the most common problems is inaccessible websites. If you're using
Yes.
a screen reader like JAWS, that you'll get, what we frequently see is people will get partway through an application and then something's scripted wrong.
Yeah.
And JAWS can only read what it's told to read. So if you have, or whatever screen reader you're using, and so if something is labeled wrong, then you as the person with vision loss can't proceed with that application because you're not able to fulfill the instructions of the application.
You get stuck. My technical term for it. I get stuck. But yeah, so and at that point, I mean, it again, should the employer, they need to be following the ADA in terms of what's being offered and the accommodations that are being made. I think what happens sometimes, and also you can get into the skills of the user. So the website could even be, at the minimum standard of what can be done, but yet maybe the individual, has recent loss of vision and they're not proficient in JAWS or something. And so there's a balance there but according to the ADA, that employer is to make those reasonable accommodations throughout the process, and they cannot discriminate based on those medical examinations.
And so then that also limits the kinds of,
or testing. Yeah.
Right. And so then that also kind of, the next one is that they have to offer a reasonable accommodation. There's that kind of catchy word, that reasonable. I think the other phrase we sometimes hear is it cannot cause an undue hardship.
Right. So you go from a reasonable accommodation. You don't move into an unreasonable accommodation because nobody wants to say, you're not worth me doing this change. So you go from a reasonable accommodation to an undue hardship when the line is crossed. And that line has to do with the size of the organization, the resources of the organization, how many people they have working, the facility you'll be working in. There's a number of factors that go into, has it become an undue hardship? So
thinking specifically about vision loss, some of the most common accommodations that our clients require on the job would be use of a screen reader or magnifying software. If somebody has low vision, the use of a closed circuit television, CCTV, or video magnifier, whatever terminology you want to use for that. That software can cost you about $1,000, and those CCTVs or video magnifiers can, depending on the size that you're looking at, can be 800 to well over 2,000. So do you find that typically employers are expected to provide that, or is that still falling under reasonable accommodation?
So again, it has to do with, let me start with this, that many accommodations, and I know you've probably experienced this, that many accommodations are very simple. I mean, many accommodations are things like the person uses paratransit or something, and so they need to change their work schedule slightly to accommodate that transportation piece. It could be that, you know, the individual is in a wheelchair and they need to have their desk put up on some blocks to make sure that the wheelchair can get underneath. You know, someone who's diabetic and might need to have snacks at certain times, or, you know, things like that. So let me first say that, you know, a lot of accommodations are simple and don't cost the employer much of anything. Now, in our case, when we talk about vision, and as you mentioned, you get into some of the software, some of the other devices that are there. It goes into, for example, the overall financial resources of the entity, the overall size with the number of employees, the number, you know, the type of the location of their facilities. I mean, and that's where, again, we're going to use that word. It's, you know, can be tricky, because if someone says, hey, I applied for this job and you didn't hire me and it was a reasonable accommodation that I asked for, and the employer comes back and says, no, that was an undue hardship. Well, now that's when you've got at times complaints, and then it's going to be looked into. And I don't know that there's an exact formula. I'm sure that there is something that's used
Yeah.
to, but it's not, you know, A plus B minus C equals D. It's looking at the overall picture of the organization.
I think you brought up a good point that, I mean, and even with vision loss, not all accommodations are expensive. It could be something as simple as unscrewing a light bulb that's directly over
Exactly.
somebody's computer. Costs you nothing other than the 5 seconds of time it took to unscrew that light bulb. So any employers on this call, please don't think that hiring a blind person means that you're going to have to spend a lot of money, because as Scott said, many accommodations that, you know,
Yeah.
we kind of forget that those are considered accommodations as well.
And I will tell you this, Jesse, too, there are throughout the country, there are these, through this Job Accommodations Network, or JAN, there are toll-free numbers that employers and consumers can call. But the employers, I actually spoke to, there was in Boston has one of the locations, and in speaking with them last year at one point, they said they get many calls from employers who want to do the right thing. They're just trying to figure out what they can do that will be reasonable, because they couldn't, you know, let's say if you're an employer that employs 20 people, so you're covered, you're a covered entity, you have to abide by this. Or you're an employer that employs 400 people. The resources for that 400 employee organization are going to be different than the resources for the 20-person organization. And so these ADA support lines you can call, employers can find out, hey, what are the best practices for this situation based on an organization of my size? And again, and you also don't have to, the employer does not have to give the employee the accommodation, the specific accommodation that the employee asked for either. So let's say that there's a particular brand of something that I would like to have, Jesse, as my assistive technology or whatever. The employer doesn't necessarily have to give me what I ask for in terms of the specific brand or that kind of thing. They have to make a reasonable accommodation in order for me to do the essential duties of that job. And so these helplines, I think, are beneficial to sort of bridge that gap. You know, how do we get to there from here and do it in a way that's a win-win for the employer and the employee?
I think that's good to note that, you know, just because you request an accommodation does not necessarily mean the employer has to provide that. The accommodation has to be reasonable and it has to be necessary.
Right.
You know, and another example that I think can get a little bit tricky that is given by the ADA.gov website is modification of job duties.
Yeah, and I, you know, that the modification of duties, or there's a line at which it becomes that you're not able to do the fundamental. So let's step back for a second. If there's a job description and there's a posting for a job and I apply for that job, and let's say the application process goes fine, let's say I then interview and all of that, and we haven't gotten into those interview type questions, but the employer really cannot ask me about my disability unless I sort of introduce my disability into the conversation. But they can ask me how I am going to perform the duties of the job. That's permissible. So when you start talking about those functions of the job, or maybe changing some of those a little bit, it's kind of getting into that area where at some point the employer can say, okay, you are not able to do the essential or the fundamental aspects of this job, so I'm not going to hire you for this job. But the employer could also at that point do some customized employment. And it really is, instead of just taking your pool of applicants and picking the one you want, it's sort of one person at a time, the employer and the applicant or the employee saying, all right, look, I've got these things that need to be done for my business. You've got this set of skills over here. I have employees who maybe if they got some of these things off their plate could focus on their revenue producing things better. And so I'm going to sort of create this new job description for this individual who has applied and has some skills and someone I'd really like in my organization. That customized employment is kind of, for me, at least in my thought process, it's a better outcome for that than, I'm going to accept you as someone who really can't do the duties of this job, but right, I'm going to hire you for it anyway. I think that just sort of sets people up for maybe not the best outcome.
Well, and it's like you are reading the PowerPoint on the screen, because our very next one is limits on questions. So that's another another piece covered by is you've kind of already given an example that they can't ask you to describe your disability necessarily, but they can say how will you accomplish this specific task, that type of thing.
They will, how, and let's just I don't want to. It's like it's sort of obvious to some extent. It's like if I'm sitting across the table from someone at an interview, and I came in with my cane, and and they go, so how are you going to carry out the duties of the job? Would they ask someone that question who's who didn't come in with a cane? I mean, very likely no, but it's almost like a nod that's been given to employers. At least this is totally Scott opinion right now.
Okay.
A nod that's been given to employers to sort of give you a question that might, but it at least allows the applicant now to explain, here's how I would carry out the duties of the job. But to me, it's not necessarily a question that they would ask of someone who did not appear to have a disability. So for what that's worth.
Okay. So then, that we're kind of shifting now out of Title I and into Title II, which Title II covers specifically government services, programs, and activities, and it's a little bit more narrow in its focus. It covers those with intellectual and developmental disabilities, and sort of one of the very specific things it covers is that these individuals need to be given every opportunity to be in an integrated setting. And so, Scott, can you talk to us a little bit more about Title II and what does all of that mean?
So integrated, we often hear in our work at Alphapointe and other organizations affiliated with the Ability One program, which also has Source America is another central nonprofit agency affiliated with the Ability One program. And Source America does focus more on individuals with cognitive or intellectual disabilities, but the term usually used is significant disabilities. And so the term competitive integrated employment is used a lot, but the integrated piece of that essentially means that the person with the disability is interacting on a daily basis with individuals who are not disabled other than their supervisor. And so that's a caveat that's put in there, or a piece that's put in there, other than the supervisor. And then that sort of this employment is typically found in the community as part of that competitive and integrated. And so integrated essentially means that you're not having your disabled employees, you have a room of disabled employees sort of all working together with no opportunity to engage with individuals who are not disabled. So the goal is integrated employment.
So how does that affect employers like Alphapointe? Because we are part of that Ability One Commission through the
Right.
National Industries for the Blind. We have certain
Yes.
jobs where 75% or greater of our
Right.
workforce by law have to be legally blind.
Yes.
So it seems like it's almost we've got two kind of competing mandates.
So we do, and part of the issue is it's a left hand, right hand sort of a thing. So if on one hand you're telling us that, and this is into some broad issues of employment law and programs, the program that we operate under at Alphapointe, the Javits-Wagner-O'Day Act, started as Wagner-O'Day Act in 1938. Was amended in 1971. Javits came and added people with significant disabilities, or at the time, severe disabilities. They typically say significant now. But so you have a program that was meant to sort of help increase the employment for people with disabilities. So part of that was the 75% direct labor ratio. And that was done for several different reasons. One is because the idea was to employ people with disabilities. So you didn't want to have people getting federal contracts that really weren't employing enough people with disabilities, and they were just doing it as a money-making sort of a venture. So you have the 75% direct labor ratio requirement. But on the flip side, you're not considered competitive integrated employment if you don't have, this integration piece. And so it's a balance. And at Alphapointe, for example, Jesse, we've got departments that certainly have more blind individuals than other departments. And yet there's a mix, there's a mix of people who are sighted, people who are blind, people that may have some other disabilities as well. Efforts are made, I know, that through engagement within the organization. So you may have events, you have meetings, you have different things where people are able to engage. And on some levels, the people that do vocational rehabilitation may consider, one department integrated and another department not integrated based on the number of disabled people to non-disabled people, and then what that interaction looks like. It's a tricky thing too, because when we say not as, otherwise found in the community, well, we do a lot of special things at Alphapointe. I'm glad we do. I mean, we do a lot of things to make sure that our blind employees can carry out the functions of their job. I wish every employer did the things that we do, Jesse, for their disabled employees. But because we do a lot of those special things, a lot of times it's not considered to be typically found in the community. Well,
Right.
darn right, it's not typically found in the community, and wish it was.
So I
But
think
there's a balance. There's a
so, and I
balance.
think kind of what, we start getting into Title II, what this is specifically
Yeah.
covering is programs like vocational rehabilitation, which we're
Yeah.
going to get much more in depth in next week
Yeah.
on next week's webinar. And so that idea of integrated employment, the person with a disability is absolutely able to choose. We have a lot of people that say, I prefer to work somewhere like Alphapointe because I know that the employer knows how to accommodate me. It's maybe the one time I'm around other people with vision loss who understand what it
Right.
is that I am going through. There's there can be a comfort factor in there. I know there's jobs, because it's not just unemployment, but underemployment that really
Yeah.
impacts, all of the community with disabilities, but vision loss in particular. When we look at the statistics of, that needle has really not moved. 70% of
Yeah.
people with vision loss who are employable are unemployed or underemployed. And so a person with vision loss or with any disability could certainly look at an organization that specializes in employment of those with disabilities like Alphapointe, and they can absolutely, because there's always that idea of consumer choice, they can absolutely choose to come work here, but it may impact things like vocational rehabilitation.
It can. And so, for example, we have people that, I'll just say from my own personal experience, right? So if I'm going to work, and certainly have had, my own business and things along those lines, is if I'm going to work with an organization, I I really like the idea of working with an organization that understands my situation, that wants to maximize my skills and help me reach my full potential. We have assistive technology experts. We've got people that have worked with blind individuals for years and years, whereas you could have an organization, a company in the community that's not Alphapointe. You could have a company that hires someone who's blind and has no clue how to help that individual do the thing. So now that individual has to become that self-advocate, or someone like yourself or others that may be helping that person with job placement in the community is now working with that employer to make sure that the proper things are done, that all of those just all of those details are taken care of so that that person can be successful. And so it is that informed choice about what you want to do and where you want to work, but because of some various laws and things, it's not always viewed that clearly.
Mm-hmm. Yeah, and so then kind of the next question that people have is, so that's great, I have all of these rights, but I believe my rights have been violated. What's next? So at that point,
Right.
that's where we start engaging the Equal Opportunity Commission, or EEOC, and they're an organization that exists not just for disability, but any type of employment discrimination.
Mm-hmm.
And if you believe that for the purposes of this particular webinar, a person who is covered under the Americans with Disabilities Act,
Right.
that you are being discriminated against because of your disability, or it can be a case of harassment. It doesn't have to be discrimination. It can also be harassment, that you're being harassed because of your disability. You are able to file a complaint with the EEOC, but there is a timeline. So you can't decide 5 years later that, oh, I was passed up for that promotion,
Yeah.
I'm going to file a complaint stating that I was passed up because I have a disability. It really depends on your location and what state and local laws are involved. But generally, you have 180 days to file. If there's state or local laws that cover that specific issue, it can bump up to 300 days. And typically, if you have multiple incidents, so an example that's given on the website is you were initially passed over or you were initially denied a job accommodation, and then later on you were passed over for a promotion. Well, each one of those is a separate incident. And so it's 180 days or up to 300 days, depending on local legislation that may alter that per incident. So it might be too late for the first incident, but not too late for the second.
Yeah.
Now, if it's an ongoing issue, particularly like a case of harassment where this may be an ongoing issue, then it becomes, your timeline starts from the date of the last incident. And in harassment cases, they will look at the overall history. But for things like being passed up for promotions, accommodations, that type of thing, they look at each individual instance separately. So you do have a time frame in which you can get this resolved. So if you do believe you've been discriminated against, it's in your best interest to initiate as quickly as possible. And they do have an online portal. They prefer you to go through that online portal, but you can also go in person to your local office, which you can go to their website to find out where that is, or you can call them. Now, they won't do the entire complaint over the phone, but you can initiate the process. You can get that process started. And that phone number, for those who are unable to see the slide, is 1-800-699-4000. I'll go ahead and repeat that number. It's 1-800-699-4000. 4,000. And we have actually here at Alphapointe worked with EEOC cases where we've had, where they've used an organization like Alphapointe. They've used us as a resource to say, this person believes they were discriminated against because they have vision loss. We need to know, can this person truly perform the fundamental aspects of the job with reasonable accommodation? And that's when our rehabilitation team of professionals can go into a business, look at a specific job and determine, yes, this person is able to do it and these are the reasonable accommodations, or no, the person was not able to fulfill the fundamental aspects of the job. And so so you do have recourse if you do believe you've been discriminated against. Scott, do you have any thoughts on filing with the EEOC?
I would just say, just so you know, the 180 days, the 300 days, depending on local laws, I would just say, if you feel like that has happened, or you have some sort of evidence that you've been, uh, um, a victim of either harassment or the discrimination, is just file. As if you truly are going to go that direction, just file as soon as possible. I think the longer you wait, memories can fade a little bit. My personal thing would be, if you find yourself in that position, is go ahead and file as soon as possible. But also, before you do that, just make sure you have, as I would often say, your ducks in a row. Make sure that you've got your documentation, if there's documentation of it. If you have some sort of evidence of that, just make sure you write everything down, that it's clear, concise, that, what has happened. Because um, even though there are protections as well as an employee if you file a complaint. I'm just going to be real, Jesse. You know that if you file that complaint, chances are the relationship with the employer, if you're still employed there, let's say, I would imagine it gets a little chilly. So just be aware of the road that you're going. So just be prepared that you've got all your documentation, and just do it as soon as possible if you're going to go that route. That's all. Yeah.
And as we mentioned, Alphapointe can help. One of the things that we really highly recommend if you are a person with low vision is coming by our low vision clinic. Our doctor is a little bit different than your typical eye doctor. So your typical eye doctor says, what are the medical procedures, medications that we can give you to slow down, halt, or, like in the case of something like cataracts, even reverse your vision loss. Our eye doctor says, we know that your vision loss is likely long-term. What lighting, magnification, or contrast can we recommend to help you make the most use of your functional vision? And so particularly when we start getting into things like employment and accommodation, this can be really a gold standard of making sure that we're taking all the guesswork out of the process. You meet with a doctor, and then we have occupational therapists, or you might be referred back to a rehabilitation team to then work with those doctors' recommendations to make sure that you can get the equipment and the training that you need to use it, because some of the stuff does have a bit of a learning curve. And then, as mentioned, our comprehensive rehab services, and we work very closely with the state rehabilitation agencies, which is actually the topic of next week's webinar, working with vocational rehab. And so if you are somebody with recent vision loss, or one of the other things that we see a lot is, as technology changes, there's updates to software programs, all of a sudden the way that, particularly for a screen reader, the way that you've been interacting with the program has suddenly changed. And so we can get you the training that you need to get comfortable with that program again and be able to get back into the workforce, take a lot of, again, the guesswork out of it. We have employment services. So something we brought up on the call today is inaccessible applications and websites are a very common problem that people with vision loss have when trying to apply. And so engaging our employment services, we can help you do that job searching, help you navigate that process, making sure that you're able to get those applications in, that you're not missing anything on the website because something got scripted wrong, that we can help you with making sure that any accommodations you need. And then sometimes, depending on the level of vision loss and the job, some people may need a little bit of training on the job for those things that they have to do differently because of the vision loss. We have our Connecting Point store, which has a variety of gadgets and just kind of, I call them our toys to help you, whether it's a CCTV, head-worn magnification devices, or audio devices that we talked about a few webinars ago, adaptive keyboards, that type of thing. And then we have our Infopointe store, which was on the your registration email, which that's just fun things like Alphapointe branded items, or things that, we have a sonic ball that you can use to play with your kids, or if you want to play with it in the pool yourself, get out of the house for a little bit with all this COVID thing. So we do have ways that we can help you. If you are wanting to donate to help support programming like this. Or if you are someone that you know has vision loss and you think that you would benefit from our products or services, you can go to www.alphapointe.org, and there is an E on the end of Alphapointe, or you can call our main number, 816-421-5848. And at this point, we're going to go ahead and open up our webinar to any questions. This is a really complex topic. We really just kind of skimmed the surface of it today. I know that we had a lot of detail in there, but this really does get to be very complex very quickly, because so much of it is based on individual cases, and then how individual case law has impacted how the law is interpreted. So at this point, if anybody has any questions about your rights under the Americans with Disabilities Act, and while we're waiting for people to type them in, next week will be the last session of our employment series, and we'll be talking specifically about working with vocational rehabilitation agencies. And then after that, we'll start our back to school series, which I know, particularly in the times that we're in right now, there are a lot of questions about returning to school or some semblance of school, particularly for our students with vision loss.
Yeah. Jesse, one thing I was just going to point out, if I was just thinking about was during this COVID time, it's been interesting because there's been some talk about like masks and wearing a mask or not. And, if you have a disability, then you don't have to, without getting into that too much. Of course, I just brought it up, so I probably did get into it, but I know, but I would say that there is information in the ADA that is interesting, and it's applicable to certain situations when it comes to vision. So for example, let's say you have an eye surgery and your vision is not correctable to a certain point for a period of time. There is a determination that if it's 6 months or less, it's considered transitory or minor. And so you do not qualify under the ADA as an accommodation or those kinds of things needing to be done. You would not be protected at that point necessarily. You may have some other protections, whether it's under a disability insurance plan or something, but 6 months or less, it doesn't really fall under, there's a specific exclusion for that. So just thought I'd point that out.
I'm glad that we have a little bit more clarification, because there are a lot of things that, you're on crutches for 6 months or less, that's impairing a major life activity or limiting a major
Probably
life
several.
Activity. Yeah. But again, it doesn't qualify under that needing an accommodation necessarily, or that, needing an accommodation, but doesn't qualify under specifically the Americans with Disabilities Act.
And if you've been employed somewhere, I mean, you would hope, right, at that point that, the employer's going to work with you, and you've been a good employee. They want to keep, it's hard to find good qualified employees and keep them. And so I hope that most employers, are going to work with someone in that position. But just so people are aware that if they did have something and went through a period of time where their vision had been affected, that if it's considered to be transitory, like it's a temporary thing, then it's just a different situation. So.
Well, at this point, it looks like this, I think, our second webinar in a row with no questions. Maybe we're just getting better about covering all the information. So we do want to thank everybody for joining us today. And again, please join us next week for the last in this employment series, and we talk about working with vocational rehab agencies, because we do work with them quite closely here at Alphapointe. And then if you are a school student, or you have kids in school, or you're just bored and want to join us, in August, we'll be starting our back to school series. So have a wonderful day and stay safe, everybody. Thank you.